Hi, I'm Max Dilendorf. I'm an attorney. We help U.S. families and international clients evaluate cross-border estate planning and asset protection strategies for traditional assets and crypto. This episode opens up our series on how U.S. courts analyze offshore trusts. Over the past 30 years, a substantial body of law has been developed where U.S. courts have attacked offshore asset protection structures and their U.S. creators or settlors. We'll start with a real case from the Ninth Circuit. That's a federal appeals court that reviews cases from the Western U.S. before anything goes for an appeal to the Supreme Court. Think of the Ninth Circuit as one level below the U.S. Supreme Court. The case we are looking at is FTC versus Affordable Media LLC. The plaintiff was the FTC, or the Federal Trade Commission, the federal agency that protects consumers and can sue in court to freeze assets and get money back when there is fraud involved. So defendants were Michael and Denise Anderson, Americans, and we'll refer to them as Andersons. They set up what's called a Cook Islands Trust, an asset protection trust that was operated by a professional trust company in the Cook Islands in the South Pacific. A Cook Islands Asset Protection Trust works by transferring your assets to an overseas trust with legal title held by a foreign trustee. And many of these asset protection trusts include a Duress clause that says if a U.S. court orders money to be returned back to the U.S., the foreign trustee would treat that order as duress, cut the settler out of control, and refuse to send the money back to the U.S. So here, the FTC was suing Andersons and wanted to make sure money would be available to help defrauded victims if it won the case. The FTC asked the federal judge to order Andersons to transfer their assets back to the U.S. This procedure is called repatriation of assets. The judge issued a temporary restraining order, or TRO, and then a preliminary injunction, both requiring the Andersons to repatriate any assets held for their benefit inside of the Cook Islands Trust. The appeals court also noted very plainly that parts of these trusts were intended to frustrate the operation of domestic courts, and more broadly, the court noted so-called asset protection trusts are designed to shield wealth by moving it to a foreign jurisdiction that doesn't recognize U.S. judgments. The Andersons wrote to their foreign trustee requesting an accounting and the return of assets to the U.S. court. The trustee responded that the U.S. order was an event of duress, removed Andersons as co-trustees, and refused to provide an accounting or repatriate the assets back to the U.S. From the Ninth Circuit perspective, Anderson's argument that we cannot comply wasn't an accident. The court concluded it's readily apparent that Anderson's inability to comply is the intended result of their own conduct, the precise goal of Anderson's trust. The Andersons argued they couldn't obey because the foreign trustee refused to cooperate, but the Ninth Circuit wasn't convinced. In short, when a structure is built to frustrate U.S. court orders, it's very hard to prove impossibility. The court found that Andersons failed to meet the burden. When the orders were not followed, the trial judge used a civil contempt. The Ninth Circuit described as follows: an old adage warns that a fool and his money are easily parted. The district court found Andersons in civil contempt of court. In finding defendants in contempt, first, the court agreed with the trial judge that Andersons remained in control of their Cook Islands Trust, and second, the court stated, while it's possible that a rational person would send millions of dollars overseas and retain absolutely no control over the assets, we share the district court's skepticism. So here is the key takeaway from the decision. U.S. judges can order money to be brought back to the US and use contempt if that doesn't happen. And if a trust is drafted so it locks up exactly when US court enters an order, courts are likely to treat that as by design, not an accident. And so the moral of this case, if a defendant says it has no control of the millions of dollars it sent offshore, that story will be tested against the real-world facts. This is episode 1 in the short series of how US courts evaluate offshore asset protection trusts. Next, we'll review other key offshore asset protection cases and their impact on estate planning for both traditional and crypto assets, including Bitcoin, Ethereum, and even tokenized securities. Before moving assets offshore and transferring title to a foreign trustee, consider getting an experienced guidance first. Dilendorf Law Firm provides confidential reviews of both existing and proposed offshore structures so you can decide if they are right for you and your family. Thank you for watching, and I will see you in the next episode.